Thank you, everyone. Please be seated. First of all, thank you, Perry, the community of Perry, for opening up your community for this big event. It's always one of the highlights of our term. So on behalf of the entire Supreme Court, thank you. And also for the litigants, it's not like you had much choice, but thank you when we told you we're going to be in Perry, that you all showed up. So thank you very much. We are here tonight in the case of State of Iowa, ex-Rel Attorney General versus Travis Autor and others. And it looks to me like the parties are ready to proceed. Mr. Weinhardt or Mr. Fautsch, who will be arguing? Thank you. You may begin.
Good evening. Madam Chief Justice, and may it please the Court. Trial by jury is how the people of a democracy keep government power in check. The public is familiar with the concept that a jury of citizens from the community must be persuaded before a court can take certain actions. But there are cases known as equitable proceedings where the parties do not have a right to a jury trial. In theory, a jury trial is unnecessary because such cases don't have the due process concerns associated with the imposition of money damages or a criminal sanction. A trial under Iowa's Consumer Fraud Act is directed to be an equitable proceeding. This should be a limiting principle. If the words equitable proceeding limit the ability of the defendant to demand a jury, then the state must also be limited to equitable remedies. For decades, however, the state of Iowa has sought and obtained enormous influence over businesses in Iowa by claiming that the phrase equitable proceeding in the Consumer Fraud Act means only that the defendant cannot have a jury decide his fate. This is an appeal to say you can't have it both ways. Either the remedies the state seeks must truly be limited to those available in an equitable proceeding, or the defendant must have a jury. Our clients have identified three kinds of relief sought by the state that go beyond an equitable proceeding and to which they have a right to a trial by jury. These three issues predominate in virtually every Consumer Fraud Act case and effectively turn every petition filed by the state into an action of law. So there are three main issues I'm going to discuss, and I'll turn to the first, which I think is probably the most convincing. The state seeks quasi-criminal penalties amounting to $40,000 per violation of the act, and in the case of the older Iowans Act, an additional $45,000 or an additional $5,000 for $45,000.
Excuse me, counsel. I think that you and your opponent agree that the right to jury trial depends on an essential nature of the case analysis. Is that correct?
That's correct, Your Honor.
All right. And we have said that when we determine the essential nature of a case, remedies are not determinative, and we sometimes said that the remedy sought is of minimal importance. Correct?
That's correct, Your Honor. It is not determinative. It is, however, it depends on the nature of the case. And so I think in the case that we're seeing here, the state is seeking a Consumer Frauds Act cause of action. Now, typically, and what the state plays substantial weight on is the idea that they would seek an injunction and that the monetary remedies that they would seek may be instant to an injunction. That's not the case here. So the state never moved for an injunction. An injunction was never available to them because our client's business was out of business.
But the state would take another view on the injunctive and say that just because you've voluntarily stopped defrauding folks would be the way they might put it, is that doesn't prevent the state from seeking an injunction, correct?
That's correct, Your Honor.
Right. And so it seems like to me that the injunctive relief ought to be part of our analysis of the essential nature. But also, should the General Assembly's specific command that these actions shall be by equitable proceedings, doesn't that weigh into the essential nature of the cause of action?
Yes, it does, Your Honor. And there's no doubt that the Act says that these are equitable proceedings, but the rest of the Act, when we are talking about potentially $45,000 penalties per occurrence, and in this case that can be every time an allegedly misleading statement was made on the radio or in a conference room attempting to sell these stem cell services.
Is there a dollar amount when that becomes punitive?
So our case law does not say that there's a specific dollar amount when it becomes punitive. It is the case, however, that in every one of these cases, we're talking about $45,000 per occurrence, it will bankrupt virtually any business. Look, the reason that we very rarely see Consumer Fraud Act trials is because these cases usually fall into one of two categories. Either it is a business that cannot withstand even the filing of a petition and it crumbles quickly, or it was a huge business that sees these sorts of cases as a cost of doing business and they pay up relatively quickly.
Counsel, is this statute unconstitutional?
Yes, Your Honor. To the extent that this statute does not permit the defendant to have a jury trial when it comes to legal claims, that would be penalties, joint and several liability, and the gross receipts. If to the extent that our client is required, at least as applied, to go to court and have these legal remedies imposed against him without a jury, that's unconstitutional.
What standard would we need to apply with the claim that we have an unconstitutional statute?
Well, so this is a correction of errors at law review for this court. And so the question for this court is to take Article 1, Section 9 of Iowa's Constitution and line it up against the Consumer Frauds Act and to determine the language of that section is that the right to a jury trial in Iowa shall be inviolate. And obviously, our contention is that it is violated because historically, when you have an action at law, you get a jury.
But don't we have a higher standard that we sometimes apply with the constitutional claim, that it has to be clearly and palpably and without a doubt unconstitutional? Isn't that a little higher bar?
I suppose that is a higher bar, but I think this is a case where we're simply lining up the statutes against each other. And so there is no daylight between the argument, or there is no daylight in the argument that the state is making that you can have a jury trial with a penalty. So whatever standard we would use, whether it's some sort of clear convincing standard or that is in some way palpable, I don't think it matters because we're comparing things that simply will never line up.
Well, Counsel, in Henlon we said that the fact that an action seeks monetary relief doesn't necessarily define the action as one of law. So how is this different?
Yes, so it is true that you can have monetary relief in an equitable proceeding, but what makes a difference is, as you described, Your Honor, the essential nature of the case. This case stops, the essential nature of this case, because of the $45,000 per occurrence penalty, stops being equitable immediately. There is no defendant who sees a $45,000 per occurrence penalty and is dealing with an equitable proceeding. The injunction doesn't matter anymore.
If this case were tried, and I know injunctive relief wasn't sought here, but in a case where the state wanted an injunction and the fine, in terms of the standard of liability or what would actually have to be proved at trial with respect to each kind of relief, is there any daylight between those two things? Like, are there different elements to obtain injunctive relief versus the fine?
Well, So the statute itself doesn't lay out particularly clearly, I was thinking, and the state says that this is a virtue of the statute, that it's fairly sort of intentionally vague and malleable to allow it to apply to various kinds of frauds. Of course, the standard for an injunction would be the typical standard for an injunction needing to demonstrate irreparable harm. The fine itself would be a violation of the statute. Importantly, the statute itself gives the courts no criteria by which to determine whether or not you should have a $45,000 fine or a $5,000 fine.
This reminds me of the topic I wanted to discuss. You kind of walked right into that path. Am I correct in reviewing the briefs that the first time you argued perhaps maybe as an alternative bifurcation of the issues? I'm trying to find, was it ever raised at the district court, and did the red brief have an opportunity to discuss that?
So, yes, Your Honor. So the air preservation issue that the state has raised, I think, are really the flip side of the same coin. So the state moves to strike our jury demand. In resistance to that, we say, look, the jury demand is proper because of the issue with joint and several liability, gross receipts, and the fine. The state says in their response, no, you can always have all of these things under the Consumer Frauds Act. The district court adopts the state's reasoning in totality. It's a one-sentence ruling from the district court simply agreeing with the state of Iowa. Now, when we talk about bifurcation, what I'm really saying about that, Your Honor, is that this is the sort of thing that courts can handle and do handle all the time. There's nothing special about a Consumer Frauds Act case that is different from other kinds of commercial
Mr. Fautsch, it does seem that the position that both sides have, at least initially, is that instead of going issue by issue on sort of like the feds do, or claim by claim on whether there's a right to a jury, or remedy by remedy, we make an overall decision based on the essential nature of the claim. Is that your position?
So, I don't think it is, Your Honor. So, yes, there is the first issue, which is determine the essential nature of the claim. And of course, going back to Justice May's question, it is not simply that we ask, as the state is asking, is this case properly docketed in equity versus at law? It's a much broader analysis, and that's certainly a much broader analysis that the United States Supreme Court does in the cases that we have cited. Now, the question, I think, the final bottom line question for our client, and I think is ultimately being put to this court, is can the state proceed seeking these kinds of remedies against our client without a jury? And so it's, I don't believe necessarily the case that this court needs to say yes or no to the district court's ruling. Did they get it right or wrong? I think there is a pathway here. I think this is going back to your question, Chief Justice Christensen, where we said, well, look, they didn't get it right because they didn't consider whether or not each one of these remedies were legal or equitable, and they may need to have a remand for an analysis of whether or not the state can proceed.
Isn't there some case law that indicates if when a matter proceeds or initiated is in equity, or it's primarily in equity, that if there are other issues in law that are kind of inextricably intertwined with that? So, for example, a claim in equity and then a counterclaim in law, our courts have held, under those circumstances, you just proceed in equity with respect to all claims. Kind of equity is the primary issue. And that's why I was asking about the substantive standard earlier. It seems like the statute says it's in equity. Maybe there are some ancillary legal issues, but if they don't present anything substantively different, then why wouldn't we just proceed in equity?
So I would take issue with the premise of the question, Justice, because it is commonplace for cases to be tried in front of a jury to have them determine the facts, to have them, in cases of mixed law and equity, the jury hears the liability questions, and after the jury hears those questions, it's for the judge to determine whether or not the equitable remedies should be applied. So I think that's the way that we handle this as a matter of district court docket management.
So which parts in this case would be tried to a jury?
So I think all of the factual claims get tried to a jury.
So liability?
Yes, Your Honor.
And what about any of the remedies?
So obviously an injunction would not be tried to a jury, it would be tried to a court. The penalty, so under the governing precedent, so the Tull case was dealing with a penalty where the United States Supreme Court says a jury is required. That case ultimately holds that a jury is required for the liability portion of it, but not for the imposition of the penalty itself.
So your bottom line, you're looking for a jury just on the liability issue?
I think ultimately that's what the Tull case would direct for this. So the question of what the penalty ought to be, I don't think there's a line entry in the verdict form for the jury to fix the penalty.
But that seems kind of odd, doesn't it? That the penalty is what gives you the right to the jury trial, but the jury doesn't. I guess that's the same in criminal law.
Yeah, that's what we do in criminal law all the time.
Who
I see that my time has expired, but I have to answer a question.
Go ahead.
If the state recovers under the gross receipts theory, who gets the money?
Well, that's a very good question, Your Honor. I think as a matter of practice, it is rare for victims to ever get the money in these sorts of things. The state, as a matter of practice, especially in their largest judgments, it goes to a trust fund. And there's actually two separate kinds of remedies here that is quite confusing in the statute. Our contention is that the state, in terms of a monetary remedy, is essentially limited to the kinds of remedies that they would be able to get under Iowa law would be the same as the restatement on restitution and on just enrichment, as opposed to complete disgorgement of all funds received for the state's trust fund.
Counsel, I just want to make sure I get your response on one last issue. In Wilson versus Dale, we said that punitive damages could be within the purview of an equity court. How does that play into our analysis of your...
So, Your Honor, I think the Wilson case is in a posit here. And the reason for that is the Wilson case is a shareholder derivative dispute. It is entirely different. It is a dispute among shareholders effectively fighting over the corporate corpus or the corporate estate trying to divide up the pie. That is entirely different than what we have here, which is the state attempting to extract a quasi-criminal penalty from a citizen. Thank you.
I'm not sure if I'm pronouncing it correct, but it's Licht. Did I get it right? Tell me what it is. Licht. There we go. I'll get it right next time.
May it please the court. Good evening. My name is Amy Licht. I'm Assistant Attorney General, and I'm here on behalf of the state of Iowa. Before turning to the remarks that I prepared, I just want to address a few points that counsel has made. First, counsel continually referred to a $45,000 per occurrence penalty. And it is, of course, the case, as the court knows, that Iowa's Consumer Fraud Act, Iowa Code Section 714.16, and the older Iowans Act, which is sort of an accompaniment to it, each authorize the court, upon finding a violation of Iowa's Consumer Fraud Act, to issue a civil penalty. That's an issue I'm sure we'll talk about. It was thoroughly briefed. It is not a $45,000 per occurrence penalty. The Consumer Fraud Act allows, but does not require, the Attorney General to seek and the court to issue a penalty of up to $40,000 per violation. The up to is an important factor. Frankly, the court simply doesn't have to issue a penalty at all.
Counsel, why is $40,000 not punitive?
Well, Your Honor, as I think was mentioned by counsel, there's no particular amount of money that is considered punitive under Iowa law. And I think that the court...
So any amount could be, the legislature could put it in any amount and it would still be considered a civil forfeiture and not a penalty?
Yes, Your Honor. I don't believe that there's any specific amount of money that the legislature could authorize that would sort of take the civil penalty and turn it into an automatically a punitive penalty.
So up to 40,000 per violation. How many violations is the state alleging in this case?
Your Honor, the state's petition does not allege a specific number of violations. The petition has a lot of facts in it, but of course this is a case that hasn't even gone to summary judgment. Certainly we haven't had a trial, so we haven't had sort of need to specify the number of violations.
One or two?
I think
Are we talking dozens or more?
it's difficult to say without having the fact laid out in front of a trial court. I think there are quite a number, but I do want to make kind of a point because I see that there's a concern, an understandable one, that you could really rack up a lot of penalties here. $40,000, that could add up very quickly. It's not an insignificant sum of money, and we wouldn't contend that it is. But I do want to point out that there's a limitation in the Consumer Fraud Act on how a court assesses what a violation is that would constitute and how you get to a penalty, because 714.16 subsection 7 that talks about penalties says that a course of conduct, there shall not be multiple violations because a course of conduct is repeated as to more than one person. So if we were to allege, for example, a particular advertisement was a violation of the Consumer Fraud Act, simply because that advertisement had been published in 10 newspapers or had been published 100 times or to 500 people, I think that the statute itself has a limitation on how many violations we could allege there. It's not simply a matter of repetition or volume.
I mean, no matter how we slice it, Ms. Licht, these distinctions that you're drawing don't really have any relation to the actual compensation to the actual victims, right? These are just, it's punitive, right?
So we don't believe that the civil penalty is punitive because
Isn't that the definition of penalty?
in a remedial statute, which is what the Consumer Fraud Act is.
If I just plain English, if I penalize my children, the whole point of it is punitive. I mean, I guess I don't understand why you're contesting this issue.
Well, I think it's because, when you look at the essential nature of the Consumer Fraud Act, which is, of course, a major element in how a court determines whether a matter should be heard in law or in equity, the Consumer Fraud Act has been consistently by this court characterized as remedial and protective. And so we don't believe that there's a punitive aspect to it. We believe that the civil penalty component of the Consumer Fraud Act enhances its remedial nature and encourages compliance.
Can I ask you a question? I think the thrust of counsel's argument is we have these constitutional rights, the jury trial, both in the criminal and the civil context. And here we're looking for kind of analogies between this cause of action and other causes of action. So you have a consumer fraud statute, which is kind of quasi-criminal. Let's just say it was criminal. There'd be a right to a jury trial. And if this particular person or entity was sued by a consumer, you'd have a civil right to a jury trial. So it seems to me that it should follow that just because it's the state kind of seeking to enforce this, that they shouldn't be denied the right to a jury trial as well. It's serving the same purpose, which is to protect them and have the community determine whether or not there should be liability as opposed to a judge. Tell me where the analogy falls apart.
So I think that the analogy, a good comparison, I think, to the Consumer Fraud Act is some of the environmental regulation cases, a couple of which are cited in our brief, where you have, in that case, the Department of Natural Resources stepping in. We cite a case where there's an anti-dumping statute, and DNR steps in and says, someone has violated it, and needs to remediate, needs to pay a civil penalty, and they're stepping in and sort of taking a step on behalf of Iowa community members in that area, right, to protect them in a way that an individual citizen would be hard-pressed to do. And that is what I think the Consumer Fraud Act is kind of how that's positioning the state. The state is stepping in because in a Consumer Fraud Act case, many consumers are simply not in a position as individual humans. They have a prior right of action, and that's a great tool. But, litigating a consumer case, a lot of times the economics of it, of course, don't make sense from the consumer's perspective. Their outlay, even if it's significant, simply doesn't justify the cost that they would
But does that convenience trump the right to a jury trial? So, I mean, essentially your argument is, well, it's hard for people to enforce their rights, so the defendants just shouldn't get a jury trial.
So I guess I wouldn't characterize it that it's a matter of convenience. I think that it's a matter of, the Consumer Fraud Act was enacted because the legislature found that there was just a tremendous amount. Consumer fraud was something that an individual island was very hard pressed to remedy. So it's not even, I think sort of calling it convenience is maybe even arguably understating the difficulty that consumers have in even identifying situations where they've been affected by or been the victim of fraud. And the state is in a really superior position to be able to to see it, to understand what's going on, and to step in and take action on behalf of a consumer in a way that I just don't think is even viable for most consumers.
As we determine the essential nature of this action, shouldn't we consider the fact that defendants have gone out of business and you haven't sought injunctive relief, so that it's really just, you're just going for money, right?
Well, so no, I mean, respectfully, I would say that we are looking to seek, we are seeking an injunction, and we really take issue with defendants or appellants' position that the injunction is not a meaningful piece of relief. It is a meaningful piece of relief because particularly the individuals involved in this case, these were closely sort of, these were not organizations with good boards of directors, they were not, publicly held, so the individuals were very closely involved in our operation, and without an injunction, there's really no reason for them not to come back and engage in additional commercial conduct in Iowa. And in terms of the financial, the monetary aspect of this, we've talked a lot about penalties, but the state seeks consumer reimbursement here. And, I really strongly disagree with Mr. Fautsch's statement that consumers rarely see money out of these cases. The Consumer Fraud Division in the Attorney General's office, we do see a whole range of cases. Some of them are against very large defendants. Some of them are against much smaller individual defendants. There's actually a case that was included in the appendix, unrelated to this one, but it included by the name of Autor, and it shows a situation where the Consumer Fraud Act, the Consumer Protection Division, sought restitution on behalf of a number of consumers in very individualized amounts because those consumers had lost money to a particular contractor. It's a great example of the kinds of cases that maybe don't make the headlines, but we, our division and the Attorney General's office overall, recovers money for individual consumers all the time.
But why are you so concerned about trying these cases to a jury? The underlying law, the legal standards are favorable to the state. The Attorney General's office tries jury cases, including civil cases, every day. You're part of the largest law firm in the state. What's the problem?
Your Honor, that's a great question. And I mean, the reality is that we look to what the statute says, and it says that civil actions to enforce this section shall be by equitable proceedings. Shall is a directive command. That's what we believe the law says and means, that these cases shall be heard by in equity, because that's what the statute has told us, and that is how the office has approached these cases for as long as the Consumer Fraud Act has been in place. So we believe that that is what the statute requires.
What's your position on perhaps then bifurcating those issues? I'm imagining maybe equitable for bench and then jury, I imagine being full of 12 consumers. So what would that look like for you?
Your Honor, I mean, I think with the legislative directive that's in there, I mean, we still think that a whole proceeding, I think that directs that the proceedings would have to be equitable in their entirety. If bifurcation, this was how this got resolved, I think that perhaps bifurcating so that issues at law, if this court were to find that, for example, the penalty could not be decided in equity because it falls outside the bounds of traditional equitable jurisdiction, then perhaps we would bifurcate for that.
Imagine hypothetically if the court were to find that that is a violation of the Constitution, then are you saying bifurcation? Are you saying the whole thing? What would you be arguing?
Bifurcation, I think, is one possibility. I think, we can, if we were directed that these cases can't in their entirety be heard in equity, they could be heard by a jury. I mean, that's certainly I think the best alternative.
Counsel, sorry, go ahead. I was going to go back to the point that you were making earlier about how the statute gives the district court discretion as to whether these penalties are imposed at all. And that discretion, I think, goes to your point, which is in equity, judges have discretion as to whether a remedy is X or Y. But that also, I think, plays into the defendant's argument that really makes this look a lot like a criminal sentencing, right? I mean, it's sort of a similar process. How do you distinguish this cause of action, this claim that the state is making from a criminal sort of claim?
I think that there are a number of important distinctions between a consumer product claim brought by the Attorney General on behalf of Iowa consumers and a criminal case. I mean, for example, the relief that we can obtain in a consumer product claim is forward-looking. There's an injunction that can prevent future misconduct. There are, of course, although the court does need to engage in a deliberative process about whether a penalty is even appropriate, and if so, what the amount and sort of frequency would be. It needs, particularly with regard to an Older Islands Act penalty, for example, it needs to look at specific considerations articulated in the law, and then even kind of going back to whether a consumer product violation has occurred at all. It has to weigh the different effects that particular allegations, like how the different allegations have arisen, for example, whether there's deception or whether there are unfair practices. But I think that the biggest distinction is that the consumer product is intended to be remedial and protective. It's supposed to protect Iowans by providing them with an injunction that protects them from this kind of conduct occurring in the future, as well as reimbursement to make them whole in a way that I don't think a criminal case can always do.
What is the historic analog for joint and several liability being imposed in a court of equity in the absence of concerted activity by the defendant?
In the absence of concerted activity? I'm not sure that I have a perfect example, except to say that particularly in a case like this, with smaller, appellants who are smaller operators, individuals who are closely involved in the operation of the businesses at hand, it's important for the district court to be able to look closely at who's been involved and to be able to assign liability based on their individual involvement after a trial's occurred.
When I think of an equitable case, counsel, I typically think of something that would also involve defenses in equity. So, for example, unclean hands or latches or something like that. These claims don't strike me as ones that would involve equitable defenses, do they? Can you think of any that we would normally think of in an equity case?
I can't say that I can. I don't know that I have a good example of an equitable defense that would arise in a case like this. And a lot of it is because, the state is coming in not as a party to a transaction, like many equitable cases arise, but as more in a regulatory capacity. And I see that my time is up.
Nice. Let's assume that the federal law, the Seventh Amendment, had been incorporated against the states. So we were dealing with a federal right to jury trial as opposed to state right. What would be the outcome in this case if we were applying federal law?
To think on that for just a moment.
And how would you distinguish toll?
So I think just Tull being the Clean Water Act case, I think there are a couple of important distinctions from Tull. First of all, setting aside the fact that Tull was decided under the Seventh Amendment, because that's your premise, Tull talks about disgorgement. And although disgorgement is available under the Consumer Fraud Act, so is reimbursement. The reimbursement is a separate remedy from disgorgement under the Consumer Fraud Act. So I think that that's an important distinction. I think the other distinction I would make from Tull is that that is a case where the United States Supreme Court, I believe, found that the two types of remedies that the EPA was seeking an injunction and payment of penalties were intertwined, or were not intertwined, excuse me, that they were authorized under separate sections of the Clean Water Act. And here, as I think the court sort of alluded to earlier, the Consumer Fraud Act doesn't separate the different violations out in that way, and they really are all grouped together. It's more of a holistic assessment.
Let me follow it up this way. Would we be doing something different under our state constitution than the U.S. Supreme Court does under the federal constitution if we were to rule in your favor? So if federal law, let's just assume that's the practice we're applicable here, what's the outcome in this case?
I actually think that under federal law, you could still reach the conclusion that the state is advocating for, which is that this is heard in equity for the reasons that I just described, which is, it's distinguishable from Tull, I think, in significant ways, and both because of the nature of the relief that we're seeking and the difference between the Clean Water Act and the Consumer Fraud Act in terms of how the government can seek relief. Thank you.
Mr. Fautsch?
Thank you, Your Honor. There is no way to distinguish Tull from the Iowa case law or from this case.
Counsel, how about the other state cases addressing their own consumer fraud acts? And am I right that a majority of other states consider their actions to be equitable? And so would we be joining the minority?
So, Your Honor, this is the first time under Iowa law that the jury question right has been put up against the Consumer Protection Act. There is no citation to another state that has faced the exact same question and come out in the state's favor.
Have other states addressed similar consumer fraud acts, or their other consumer fraud acts have civil penalties, as I understand? And Nebraska would be an example. Yet the Nebraska Supreme Court still found that to be equitable.
So other Supreme Courts certainly have addressed the question of whether or not the penalties are available, but there has not been a citation to a case that squarely says that the jury right here, especially as it relates to a penalty capable of absolutely crushing a business, is one that is equitable in all cases. Look, we're having a discussion here about what the jury trial right means in a democracy. And the jury trial right does two things in a democracy. One, it allows 12 people, or 8 in a civil case, to say, state, you didn't prove your case. But the thing that it really does is it says to the courts, you don't have the power to issue this kind of remedy, this kinds of relief, or to the state, you don't have the ability to come into court and demand this kind of relief unless you involve the citizens of the democracy as well. We are circumscribed in our ability to haul people into court and to assess certain penalties against them by the existence of the right itself. And so if we're, I think, being faithful to the jury trial right here, we have to consider that there really is no meaningful daylight between the federal jury trial right and the Iowa right.
Counsel, do we have a case from the founding era in which the legislature has said equitable proceedings shall govern?
A case from the founding era, I don't believe we do, Your Honor. If you're familiar, as I'm sure you are, with how the United States Supreme Court deals with these questions, they try to analogize to what the King's Bench would have been doing in England, and is this better analogized to an action at debt or an action to abate a public nuisance? And there's that sort of historical analysis. We don't think that sort of historical analysis is at all necessary in this sort of case because of how egregiously these sorts of remedies push beyond the bounds of equity. To be plain, the $40,000 penalty or $45,000 penalty in the case of adding the older Iowans penalty on it is everything. In settlement negotiations...
So that goes back to my question then. When is it not punitive? Is $10 punitive?
It certainly can be. And
you would say that, so if we had a statute that allowed us $10 civil penalty, then you say you're entitled to a jury?
Oh, well, potentially, Your
In
Honor.
this exact situation, that it's $10 instead of $4,000.
So very unlikely in the context that it
Okay,
would in
so,
fact be
so not $10,
penalty.
$1,000, 10,000, that's what I'm trying to figure out where that line might be.
So
Where
look,
we
Your
need to
Honor,
draw it.
to borrow famous line from a United States Supreme Court justice, you know it when you see it. And even a $10 penalty.
Let me, isn't the Wilson case a problem for you? I mean, we said there that a stockholder derivative action seeking what seems to be ordinary damages was not triable to a jury, directly disagreeing with the United States Supreme Court's view under the Seventh Amendment under federal law. Isn't that a problem?
I don't think it is, Your Honor. And I think the important thing about this is when we think about cases that are normally tried at equity, we are talking about something where there is a corpus or an estate that the court is trying to divide up in an equitable manner. So we don't think twice about a divorce where there is an equitable estate that we're simply trying to divide up. In the case of a corporate derivative action, we have what belongs to the corporation, its claims and its assets being the thing that we are looking to divide or determine whether or not the corporation should move it forward. It is an entirely different situation.
But isn't that, go ahead, I'm sorry.
Well, and maybe we're about to make the same point. Isn't what the Consumer Fraud Act is doing is sort of taking the corpus that should rightfully belong to consumers and getting it, acquiring it through these penalties, and then potentially divvying it up?
No, Your Honor, because there is absolutely the capability for double dipping of damages here. You have the disgorgement or the reimbursement that the state seeks, and on top of that, there are penalties. So we're talking about the ability to not simply take the money back, which would be sort of your typical equitable claim, but the penalties on top of that that we allege are quasi-criminal and absolutely require a jury to resolve.
Counsel, if I may, Chief, red lights on. One of the hallmarks of equity courts is that judges have jurisdiction largely to sort of do what is fair, right? The remedies that judges have are very broad. How do you respond to what we did in the Virtue case, where we increased, this court increased the amount of the civil penalties? Doesn't that show that at least this court at one time believed that it sort of had that equitable power to do more than what even the district court did?
So in that case, Your Honor, the question of the scope of the jury trial right was not squarely before this court. The decision says what it says and it has the outcome that it has, but I think it was not conceived directly against the question of what the jury trial right circumscribes the ability of the court and its litigants to seek. Thank you.
Thank you. Case of State of Iowa, ex-rel Attorney General versus Travis Autor and others is hereby submitted.